Now today, as you all know as well, we're also marking National Gun Violence Awareness Day.
So in California, it was extremely difficult. California had to get rid of that good cause or just cause requirement
of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
But I guess the other thing, the back door to, well, the assault weapons, absolutely, because there's no definitive.
I think worse than that, sir. You will see millions of otherwise law-abiding citizens.
The Supreme Court is putting on hold a lower court ruling barring the government from regulating so-called ghost guns.
Because they're easily available on the internet and hard for law enforcement to track.
This is a violation of that federal law. The federal judge that initially ruled in this agreed, saying it's up to Congress.
Pistol, it can become a short-barreled rifle, and then it's subject under the National Firearms Act. That's what you're saying.
Well, I've got here the actual original brace that this letter was responsive to.
A divided Supreme Court today allowing the Biden administration to continue enforcing regulations on ghost guns.
ATF's bump stock regulation under fire. The ATF's got their hands full, and it's not just with paperwork. Their move to ban bump stocks got them into a serious pickle. These little gadgets are attachments that can speed up a rifle's firing rate, and the ATF thought they could regulate them out of existence. But oh boy, did that cause a ruckus. Picture this: the ATF laying down the law saying bump stocks are a no-go. People weren't having it. They argued it was an infringement on their Second Amendment rights, and the Sixth Circuit, in a recent showdown, came in swinging, declaring the ATF's ban on bump stocks as unconstitutional. Boom! That's a big slap on the wrist for the ATF. This decision wasn't just a small hiccup. It was like a cannonball hitting the ATF's authority square in the chest. It basically said, hey ATF, you're overstepping your boundaries here. And that's a big deal because when it comes to regulating firearms, there's this delicate dance between what's legal and what's not. The Sixth Circuit basically said the ATF danced a step too far. The ruling was a game changer. It didn't just say, hey, you can't ban bump stocks, but it also questioned the ATF's power in making rules that mess with our rights to keep and bear arms. It's like telling your boss they can't just change the office rules on a whim without consulting the team. The Sixth Circuit was like, hold up ATF, you can't just make these rules whenever you feel like it. This decision isn't just about bump stocks. It's a showdown about who gets to call the shots when it comes to gun regulations. It's a bit like a tug-of-war between those who want stricter controls and those who want to keep their firearms rights intact. The ATF might have thought they were doing their job by trying to tighten the reins on bump stocks, but the Sixth Circuit ruling put them on notice. It's a warning sign flashing in bright neon lights saying, watch out, you're treading on thin ice. So what happens next? Well, this ruling isn't the end of the story. It's more like a cliffhanger in a thrilling series. The ATF might appeal this decision or take it up a notch to the big leagues, straight to the Supreme Court.
If you get not denied for a firearms purchase under NICS.
The co-chair of the Second Amendment Caucus, Mr. Massey.
That is so incredibly broadly written, it will ban.
It is reported from the Rules Committee against any resolution reported.
And then there's one that Senator Feinstein just introduced, where it's an assault weapons ban.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
Which again, you might say, well, how is that objectionable if we're keeping guns out of the hands of the criminals?
Mm-hmm. California knows how to do these things well, and they know how to work around things so that they can just draft this new law.
And now the ATF, under the guidance of this administration, is coming to take away.
Under any administration, would become an ally. It needs to go. We need to abolish.
The impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
And trust me, that's where the real showdowns happen. This whole saga is like watching a legal drama unfold in real life. Will the ATF come back swinging? Will the Sixth Circuit's ruling hold up in the big leagues of the Supreme Court? It's a nail-biter, and everyone's watching to see how this game plays out because, at the heart of it all, it's about our rights and who gets to decide the rules of the game. Sixth Circuit ruling. Alright, buckle up for the legal roller coaster that went down at the Sixth Circuit. They didn't just drop the mic, they set off fireworks with their ruling on the ATF's bump stock ban. So here's the deal. The Sixth Circuit basically wagged its finger at the ATF saying, hold your horses, you're stretching way too far. They took a hard look at the ATF's ban on bump stocks and went, not on our watch. Why? Because they felt the ATF was playing fast and loose with their power. They accused them of overstepping their boundaries, especially when it comes to messing with our Second Amendment rights. It's like they caught the ATF trying to pull a sneaky move and said, "Nuh-uh, not cool." But here's where things get a bit murky. The court didn't just say, "Hey ATF, you're overreaching." Nope, they dove deeper into the legal dictionary and found themselves tangled in a web of words. See, there's this term called mash gun, and turns out defining it is trickier than untying a knot in the dark. The Sixth Circuit was scratching their heads over what exactly qualifies as a mash gun. It's not as straightforward as you'd think. There's this ambiguity in the definition, and it's causing a real headache. Imagine a bunch of lawyers arguing over whether a tomato is a fruit or a vegetable. That kind of confusion. This fuzziness in the definition of mash gun had the court and other legal hotshots spinning in different directions. They're all staring at the same law book, but they've got their own ideas about what those words actually mean. It's like trying to follow a map with multiple paths, and nobody can agree which road to take.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
And they're turning it into 10 days plus a number of steps that you have to take in order to clear your name.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
Do you think we're our safeguard on this one is there's no way that the Supreme Court will allow this, or is...
If you did, you still couldn't use it because you couldn't go about your daily life without crossing through some type of sensitive location.
All kinds of firearms that take detachable magazines.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
The ATF, before they abolish our Second Amendment rights, alcohol, tobacco, and firearms,
makes it less likely for people to shoot things they are not aiming at.
So with this ruling, the Sixth Circuit not only told the ATF to dial it back, but also highlighted this major head-scratcher in the law. They basically said, "Hey lawmakers, can we get some clarity here? We're all reading the same lines, but we're seeing different movies." This ruling isn't just a slap on the wrist for the ATF, it's a spotlight on a legal puzzle that needs some serious sorting out. It's a wake-up call for everyone to get on the same page about what these crucial terms mean, because until they do, it's a wild guessing game and nobody likes playing legal charades. Chevron deference versus rule of lenity. Alright, let's dive into the legal boxing ring where two heavyweights, Chevron deference and the rule of lenity, are duking it out over how we interpret the law. Picture this. A courtroom showdown with these two legal concepts going head-to-head. First up, we've got Chevron deference, a concept that's got everyone debating whether courts should give a big thumbs up to the ATF's take on vague laws. It's like saying, hey, if the law's a bit blurry, should we let the agency blur it even more? Some folks are all for it, thinking, well, the ATF knows their stuff, right? But others aren't so sure. They're raising their hands saying, hold on a second, let's not hand over all the power to the agency. On the other side of the ring, we've got the rule of lenity, playing the underdog role. This rule's like the rebel in the legal world saying, hey, let's not make things more confusing than they need to be. It's all about putting the citizens first, making sure the interpretations of the law benefit us regular folks, rather than giving the agency a free pass to call the shots. So imagine this debate as a tug-of-war between giving the ATF a gold star for their interpretations and saying, nah, let's keep things crystal clear for the rest of us. Chevron deference has its supporters waving the agency flag saying, hey, they're the experts, let's trust their judgment. But the rule of lenity's crew is in the stands shouting, wait a minute, let's not forget who the law is supposed to protect, us. It's a bit like giving the referee's whistle to one team and hoping they play fair. Some think the ATF should get a nod of approval for making sense out of unclear laws.
The last case that they rendered a decision in that was tangentially related to the Second Amendment was in 2016.
So in California, it was extremely difficult. California had to get rid of that good cause or just cause requirement.
Then the White House walked back that statement.
Of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
Personally, it's a little bit sketchy there too, because, you know, the last case that the Supreme Court took and rendered a decision on
of 2022. Now, when it was originally introduced, it was the worst carry bill that I have ever seen.
A real Second Amendment case was in 2010 in McDonald v. City of Chicago.
Individuals who own pistol braces, which were originally approved by the ATF themselves.
And every conservative in this Congress to stand with Representative Clyde and his legislation and to stand with me.
Now, you could argue, actually, that the pistol brace makes the gun safer.
But others are saying, let's put the interests of the people front and center, not just what the agency prefers. So, who wins this legal tug-of-war? It's not just about picking sides, it's about deciding whose interpretation of the law gets the thumbs up. It's a battle between giving agencies the benefit of the doubt and making sure the law leans in favor of the folks it's meant to protect. And let me tell you, this debate isn't ending anytime soon. It's a heavyweight bout that keeps the legal world on its toes. ATF's inconsistent stance. Alright, imagine the ATF doing a bit of a two-step dance with bump stocks, trying to define them and, well, tripping over their own feet in the process. It's been a bit of a roller coaster ride with their flip-flopping on whether these things count as mash gun parts or not. So here's the scoop. The ATF couldn't seem to make up its mind about bump stocks. First they're like, yep, these little gizmos turn a semi-auto rifle into a mash gun. And then out of the blue, they're doing an about face, saying, wait, scratch that, they're not quite the same thing. This back and forth left everyone scratching their heads. It's like trying to follow a GPS that keeps changing directions. It's confusing. And this inconsistency in the ATF stance didn't just add a sprinkle of confusion, it poured a whole bucket of uncertainty into the mix. Lawyers and gun enthusiasts alike were left wondering, what's the real deal here? But wait, the plot thickens. Instead of taking this hot potato of a legal mess and passing it around for more review, the ATF decided to go all in. They skipped the middle steps and took the elevator straight to the top floor, the Supreme Court. Yep, they're like, alrighty folks, let's settle this once and for all at the big leagues. It's a bold move, no doubt. Rather than tiptoeing through more rounds of reviews and debates, they're saying, let's go straight to the boss and get this sorted. They're basically asking the Supreme Court to give their rule on bump stocks a big old stamp of approval.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
And call on young people to continue leading efforts to end gun violence.
But I guess the other thing, the back door to, well, the assault weapons, absolutely, because there's no definitive
tearing apart families and making our streets less safe.
But let's just say that you actually did get a permit under the original SB2.
And then 1446 is where they're taking the 3-day default proceed.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
Because Bruin said that that's unconstitutional, so they drafted SB2, which was originally introduced back in December.
Which changes now we have an administration that is desperate to erode our Second Amendment rights.
Should be the name of a chain of convenience stores in Florida, not a federal agency.
Chose to apply the mindset of an authoritarian, gun-grabbing bureaucrats we all know that they are.
Now, some might say it's a bit like skipping a few chapters in a book to get to the ending, but hey, when you've got a legal tangle as naughty as this one, maybe cutting to the chase isn't such a bad idea. So the ATF's doing the legal equivalent of putting all their chips on the table. They're saying, hey Supreme Court, we need your blessing on this one, and you can bet your bottom dollar that this move is making waves in the legal world. It's like the grand finale of a fireworks show, the big moment everyone's been waiting for. Now, all eyes are on the Supreme Court to see how they'll unravel this bump stock mystery once and for all. Circuit Court cases heading to SC. Hold on to your hats because things are heating up as not one, but multiple cases surrounding the ATF's bump stock regulations are making a beeline for the Supreme Court. It's like the grand finale of a legal blockbuster, and everyone's holding their breath to see how this showdown unfolds. So why is this such a big deal? Well, picture this. Multiple circuit courts, each with their own take on the ATF's rules regarding bump stocks, are now knocking on the Supreme Court's door. It's like a chorus of legal voices, all singing different tunes, and they're looking to the Supreme Court to be the ultimate conductor. This attention from multiple circuits is like shining a spotlight on a stage where the Supreme Court is about to take center stage. And let me tell you, when the Supreme Court steps in, it's not just about settling one case. It's about setting the tone for how similar cases will be handled in the future. This isn't just a bump stock battle, it's a precedent-setting spectacle. The Supreme Court's decision here isn't just about these specific cases. It's like laying down the law for future cases to follow. It's a bit like the referee blowing the whistle and saying, all right folks, this is how we're playing this game from now on. And let's talk outcomes. The Supreme Court's review of these cases isn't just about settling disputes over bump stocks. Nope, it's like untangling a knotty mess of conflicting interpretations across different circuits. By wading into these cases, the Supreme Court has the chance to straighten out these contradictions and make sure everyone's singing from the same legal hymn sheet. But wait, there's more. This isn't just about bump stocks, it's about the bigger picture. The Supreme Court's decision could have ripple effects, influencing broader firearms regulations. It's like dropping a stone in a pond and watching the ripples spread. What happens here could set the tone for how gun regulations are approached across the board. So this isn't just a legal showdown, it's a potential game changer. Everyone's on the edge of their seats, waiting to see how the Supreme Court will untangle this web of conflicting interpretations and potentially shape the future landscape of firearms regulation. The stakes are high, the spotlight's on, and the Supreme Court's about to take a swing at a legal curveball that could rewrite the rulebook. ATF pistol brace rule. In January 2023, the ATF dropped a shocker on gun owners, introducing a rule that stirred up quite a storm in the firearms community. This rule came down heavy on folks who owned AR and AK pistols, tricked out with those nifty pistol braces. The deal was simple, but not exactly sweet. Either register your firearm with the ATF or kiss it goodbye by destroying it. Ouch. Now, let's rewind a bit to understand how we got tangled in this mess. Back in the day, around 2012, a fella named Alex Bosco had a light bulb moment. He cooked up this genius contraption called the pistol brace, not for kicks and giggles, but to lend a helping hand to a disabled veteran who wanted to shoot an AR better. Good old Alex sent his brainchild to the ATF asking, "Hey, is this cool?" The ATF, after giving it a once-over, shrugged and said, "Yeah, you're good to go." And thus, the pistol braces were welcomed into the gun world with open arms. They weren't just a hit with the disabled community, they caught the eye of everyone else too. See, slapping a traditional stock on a short-barreled gun was a red tape nightmare. It meant doing the ATF tango, registering, paying a hefty $200 tax, and waiting 3 long months for the ATF's nod. So when these pistol braces came around, making AR and AK pistols a heck of a lot more user-friendly without the bureaucratic hassle, people jumped on the bandwagon faster than you can say, Second Amendment. But here's where things took a nosedive. The ATF, after giving the green light to these pistol braces, started getting a tad grumpy. They didn't quite fancy the idea of folks skirting around their stringent rules by slapping on these nifty braces. So they tried pulling a fast one by twisting and turning the language of their own rule. For over 5 years, they danced around trying to tweak things, but nothing stuck. You see, the ATF can make rules, but can't just snap their fingers and create laws out of thin air. Crafty, huh? As time passed, gun companies started selling AR and AK pistols pre-fitted with braces. This didn't sit well with the ATF, feeling like the game wasn't going their way. So, what do you do when you can't win by playing fair? Well, you try flipping the board and changing the game, and that's exactly what they did. On January 31st, 2023, the ATF dropped the shocker, publishing a new rule that had gun owners scrambling. Suddenly, all those beloved guns with pistol braces were now slapped with a label, SBRs, or short-barreled rifles. Cue the panic. Owners had 120 days to make a tough call, either kiss their brace-equipped guns goodbye or register them with the ATF and fork over $200. But hold your horses, there's more to this roller coaster ride. Several groups, including the Firearm Policy Coalition and a bunch of brave individuals, stood up to challenge this rule, and you know what? The courts agreed. The judge slammed the brakes on the ATF's rule, saying, "Hey, you can't do that."
Is the goal of the ATF to go after and criminalize law-abiding Americans?
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
This ruling has effectively, and for now at least, killed ATF's pistol brace.
I want to get a better sense of where the ATF's pistol brace rule derived from.
It was a victory for the everyday gun-toting folks, a ruling that said, "Enjoy your braces, y'all. No need for registrations or taxes." Phew. That's the story of how a seemingly harmless Ain't that a wild ride? Legal challenge and court ruling. Alright, buckle up for the legal showdown that ensued after the ATF dropped their pistol brace shocker. When the ATF laid down the law, various heavy hitters in the firearms world weren't having any of it. Groups like the Firearm Policy Coalition and Maxim Defense, along with some gutsy individuals, suited up for battle. They rolled up their sleeves, marched into court and said, "Hold up, ATF, you can't just change the game like that." The legal tussle didn't just hang around in any old court. No, sir. It made its way up the ladder to the big leagues, the Fifth Circuit Court of Appeals. Picture this as the grand arena where the big shots spar it out. Here, these groups and individuals laid out their case, arguing tooth and nail against the ATF's rule. They presented their evidence, legal jargon flying left and right, making a solid case against the ATF's overreach. And guess what? The judge saw their point. This ain't some movie where the big bad government agency gets away with it. Nope. The judge slammed the gavel and issued what's called a preliminary injunction. Translation? The ATF had to pump the brakes on the rule. It's like a timeout in a basketball game. The judge said, "Hold your horses, ATF. You can't enforce this rule, at least not right now." That ruling was like a victory bell ringing for those challenging the ATF. It was a win for the little guys standing up against what they saw as government overreach. The court basically said, "You can't just stomp on people's rights without crossing your T's and dotting your I's, ATF." It was a moment where the little guy won around against the big bureaucratic mash. And let me tell you, in the legal world, that's no small feat. Implications of the ruling. Oh boy, when that judge dropped the hammer on the ATF's rule, it sent ripples across the entire country. Picture this, a nationwide sigh of relief from gun owners. Why? Because that ruling didn't just apply to a handful of folks, it had an impact from sea to shining sea. The judge's decision was like putting a giant padlock on the ATF's ability to enforce that rule on anyone, anywhere, in the good old US of A. What does this mean for the folks with AR and AK pistols decked out with those handy pistol braces? It's like breaking free from the bureaucratic shackles. Suddenly, it's open season. You can strut around with your brace-equipped firearm without worrying about the ATF breathing down your neck. No need for registrations, no hefty $200 tax. You're free as a bird to enjoy your guns as they were meant to be enjoyed. Think of it as a victory lap for gun owners, a win for the right to bear arms without unnecessary red tape. That ruling basically said, "Hey ATF, you can't just flip the script and change the rules midway, not on our watch." It's a thumbs up for individual freedom and a reminder that the government can't just bulldoze over people's rights without a darn good reason. So cheers to the folks out there who can now sling their AR and AK pistols with braces without a worry in the world.
And would not alter the classification of a pistol or other firearm.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
ATF derives its rulemaking authority in this matter from primarily the National Firearms Act.
Classification changes for previously registered guns. Here's where things get a tad more complicated. Remember that 120-day window the ATF gave folks to make a tough call about their brace-equipped guns? Well, for those who bit the bullet and registered their firearms during that time, there's a bit of a twist in the tale. Those firearms are now stamped with a new label, SBRs, which stand for short-barreled rifles. It's like a rebranding, a new classification that comes with its own set of rules and quirks. So if you were one of the brave souls who said, "Okay ATF, I'll play by your rules," your gun is now officially in a different category. Now let's talk about adding a stock to these SBRs. You see, adding a stock to these firearms isn't as simple as slapping on a new accessory. If you decide to give your SBR a makeover by adding a stock, you'll need to tap the ATF on the shoulder and ask for permission. Yep, it's like needing a hall pass to cross state lines, but for your firearm.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
This means that while these previously registered guns get a bit of a different status, there are still strings attached. It's like getting a backstage pass to a concert, but being told you can only go to certain areas. Your gun's got a new identity, but it comes with limitations when it comes to modifications and interstate travel. It's a bit of a bittersweet deal for those who registered their firearms within that 120-day period. Sure, they don't have to say goodbye to their beloved guns, but there are now some hoops to jump through if they want to make any significant changes or take their firearms across state lines. Future of ATF enforcement and gun ownership. The legal dust may have settled for now, but the story doesn't quite end there. You see, the ATF isn't exactly known for taking a defeat lying down. There's a chance, albeit a slim one, that they might try to pull a rabbit out of their hat by appealing the court's decision. Picture this, the ATF dusting themselves off, adjusting their tie, and saying we're not done yet. Now, is that likely? Well, let's just say it's about as probable as finding a unicorn in your backyard. The court slapped down their rule, saying it was a no-go, and for the ATF to turn that ship around and win an appeal, it's like trying to swim upstream with a cinder block tied to your ankle. But hey, stranger things have happened. Remember, this is the real world. not a predictable movie plot. So while it's not impossible, it's about as probable as finding a needle in a haystack. Now let's talk shop for gun owners. That court ruling? It's a green light. It's like the freedom bell ringing loud and clear for folks who want to buy and use AR and AK pistols with those trusty braces. No need to peek over your shoulder or worry about the ATF knocking on your door. You're free to shop for those firearms and deck them out with braces to your heart's content. It's a victory for individual rights, a win for gun enthusiasts who just want to exercise their Second Amendment without jumping through hoops. The ruling sends a message, hey, you can't stomp on people's rights without a darn good reason. So for now, it's a thumbs up for gun ownership and a big take that to unnecessary restrictions. Who knows what the future holds, but for the time being, it's a celebration for folks who cherish their firearms and the freedom to use them as they see fit. That's all for this Supreme Court's involvement in ghost gun regulation. The Supreme Court showdown over ghost guns, where the Biden administration's efforts to rein in these sneaky firearms collided head-on with legal battles. In this 5-4 nail-biter, the Supreme Court hit pause on a lower court's decision that threw a wrench into the ATF's regulations on ghost guns. Surprise, surprise, Chief Justice John Roberts and Justice Amy Coney Barrett, teaming up with the liberal justices, pumped the brakes on that lower court ruling. On the other side, Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh were standing firm against the Biden administration's plea. And here's the kicker. This decision meant the ATF's restrictions on these untraceable firearms could stay put while the legal wrestling match continued. It's like a timeout in a high-stakes game, giving these regulations a breather amidst all the legal back and forth. Picture this standoff at the highest court, where some justices formed an unexpected alliance to keep these regulations in play while the legal drama unfolds. It's a temporary win for those aiming to tighten the leash on ghost guns, but the battle is far from over in this courtroom clash. Biden administration's efforts to control ghost guns. The Biden administration wasn't sitting idly by when it came to tackling the ghost gun conundrum. Picture this. They rolled out this heavyweight rule through the ATF in August 2022, aiming to put a lasso around these untraceable firearms that were popping up all over thanks to those crafty DIY kits available online. What was this rule all about? It was a revamp of the Gun Control Act's definition of firearm, zeroing in on those ghost guns made from kits. The goal? To slap some much-needed regulations on those sneaky creations. But here's the thing. They weren't banning the sale, purchase, or possession of the guns. They were going for a more strategic approach. Licenses, serial numbers, background checks, and keeping tabs on records for specific kits became the name of the game.
The Supreme Court is putting on hold a lower court ruling barring the government from regulating so-called ghost guns.
In the view of this White House, that includes allowing a federal agency like ATF to regulate the scope.
Supreme Court decision basically pauses a lower court decision that blocked the Biden administration.
Because they're easily available on the internet and hard for law enforcement to track.
It was like putting guardrails on these DIY projects without stopping folks from building them. Imagine it like this. The administration wanted to make it a bit tougher for these untraceable firearms to sneak into the mix without putting a full stop on the hobbyist gun-making scene. So they set out to sprinkle a bit of regulation magic on these kits, aiming to make sure they didn't slip through the cracks without a trace. ATF's rule and legal challenge. Talk about a bumpy ride for the ATF's rule on ghost guns. As soon as the ATF put forward those regulations, there was a whole chorus of challenges ringing out. Gun owners, advocacy groups, and sellers weren't exactly throwing a party in celebration. Instead, they banded together, claiming that these restrictions were overstepping their bounds. They argued that the ATF had gone a tad too far, waltzing outside their statutory authority. And guess what? The legal tango ensued. A district court took the first swing, blocking some of those provisions faster than you can say ghost gun. But that wasn't the end of it. Oh no. In July 2022, things took a turn when a judge sided with the plaintiffs, slamming the brakes on the regulation nationwide. It was like a giant red stop sign suddenly appeared, putting the kibosh on these regulations from coast to coast. So imagine this regulatory journey hitting roadblocks left, right, and center. The courts were dishing out decisions that seemed to throw a curveball each time, leaving the ATF's rule caught in this legal tug-of-war. Just when it seemed like progress was being made, the legal gavel came down hard, hitting pause on those regulations and stirring the pot for more legal showdowns. Impact of ghost guns on crime and communities. Let's talk about the real-world implications of these ghost guns. They're like a wild card in the deck, causing some serious headaches. The big worry? These untraceable firearms sneaking into communities like shadowy accomplices, potentially giving a helping hand to the wrong crowd. It's the kind of situation that had the Biden administration scrambling to put a lid on it. Why all the fuss, you ask? Well, once these untraceable guns are out there in the wild, sold and without a trace, they're like a ticking time explosive. They pose a real conundrum for law enforcement. Imagine trying to solve a puzzle without all the pieces. That's the challenge these ghost guns throw at the folks trying to keep our streets safe. It's a genuine concern because once these weapons hit the streets, they're a blank page as far as tracing their origin or tracking their use. They become a wild card in crime scenes, making it incredibly tough for law enforcement to connect the dots. And that's precisely why the Biden administration stepped in, trying to curb this trend before it snowballed into a bigger problem. Ghost guns might seem like a distant, mysterious concept, but their impact hits home when it comes to community safety. ATF's directive on unfinished handgun frames. Let's talk about the ATF's new directive. It's a game changer in the world of unfinished handgun frames. Imagine this. The ATF stepped in and said, hey vendors, those partially finished frames, treat them like the real deal. It's like turning the spotlight on these half-done frames and saying, you're not escaping the rules. Now, what does that mean in plain English? It means these once under-the-radar frames now need to play by the big rules. They've got to sport serial numbers, just like their fully assembled cousins.
The Supreme Court has voted to reinstate regulations on untraceable homemade weapons known as ghost guns. The administration issuing those regulations last year, saying the guns are a major threat to public safety.
Crime in major cities in recent years. The weapons can be bought online.
The High Court's ruling grants the Biden administration's request to let the regulations remain in effect.
And buyers? Well, they're not getting off easy either. Now they've got to go through those background checks. A move that's like putting a lock on the door of easy access to these unregulated frames. This change in the game could put the brakes on the sale of these frames that have been linked to all sorts of unsavory stuff. It's like shining a light on a previously shadowy corner of the market. By imposing these stricter regulations, the ATF's essentially making it tougher for these unfinished frames to slip through the cracks, potentially disrupting the flow of unregulated parts into the wrong hands. Gun safety advocates were quick to cheer as the ATF made its move towards stricter regulations on ghost guns. It was like music to their ears, a round of applause echoing across the advocacy groups. Finally, steps were being taken to rein in these elusive firearms that had been causing quite the stir. For them, it was a victory, a step towards making communities safer. These groups weren't just clapping from the sidelines either. They were front and center, urging the ATF to step up and take decisive action. It wasn't just a casual nudge, it was a loud chorus of voices calling for action. They saw the growing issue of untraceable firearms as a ticking time explosive, and they weren't about to sit back and watch. Advocacy groups didn't just want talks or promises, they wanted boots on the ground, regulations in place, anything to tackle this rising problem. It was a rallying cry for change, a push to make sure these ghost guns didn't slip through the cracks anymore. Their support for the ATF's move wasn't just about celebrating a win, it was about pressing for more. They knew that stricter regulations weren't just about paperwork or rules, they were about potentially saving lives. So for these advocates, every step forward was a victory in the battle for safer communities, and they weren't about to back down until they saw real change take root. When the ATF dropped its shocker of guidance on the gun industry, you could almost hear the collective scratching of heads. Gun industry reps weren't exactly popping champagne. Instead, they were raising eyebrows, expressing their fair share of confusion. They weren't shy about voicing their concerns either, waving the flag of potential legal challenges high in the air. Their big gripe? They saw this new guidance as a potential slap in the face to the Gun Control Act.
A divided Supreme Court today allowing the Biden administration to continue enforcing regulations on ghost guns.
Last year, the Bureau of Alcohol, Tobacco, Firearms, and Explosives updated its regulations to define the kids.
The appeals court that was asked to step in and allow the regulations to continue agreed with the district court judge.
Ghost guns are firearms without serial numbers, making them practically untraceable.
It wasn't just confusion in the air. There was a palpable sense of anticipation, too. The industry wasn't gearing up for a celebration. They were strapping in for a legal roller coaster ride. There was this looming expectation of legal battles looming on the horizon, and they weren't expecting tea and cookies. It was more like a heavyweight showdown. And guess who was gearing up for this legal tango? Gun rights groups were front and center, polishing their legal swords. They weren't just sitting around twiddling their thumbs. They were ready to charge headfirst into legal battles against this guidance. It was a clash of ideologies, a battleground where regulations collided with rights. In this game of legal chess, everyone was eyeing their next move. The industry was wary, the gun rights groups were ready to fight, and the legal battlefield was all set for a showdown. It was the calm before the storm, with legal challenges brewing and industry players gearing up for a fight to defend their turf. State and city measures to regulate ghost guns. In the midst of this ghost gun chaos, states and cities were rolling up their sleeves, taking matters into their own hands. Places like New York, Washington, and Los Angeles weren't just sitting around twiddling their thumbs. They were diving headfirst into the fray, passing laws or even taking manufacturers to court, all in the name of reining in those sneaky ghost guns. But here's the twist in the tale. Not every state or city responded in the same way. It was a patchwork quilt of reactions. Some states, fired up and ready to make a change, went full steam ahead, enacting their own regulations to curb the ghost gun surge. It was like putting up their own roadblocks against these untraceable firearms.
The Supreme Court has decided for now that the Biden administration's crackdown on so-called ghost guns.
This is a violation of that federal law. The federal judge that initially ruled in this agreed, saying it's up to Congress.
And they're saying, they have the authority to do that. The gun rights groups that are suing
on ghost gun kits, which make firearms untraceable. The regulation will be in effect while the administration appeals the ruling.
However, not everyone was singing from the same hymn sheet. Some states found themselves butting heads with federal rules, facing off in legal showdowns. It was like a tug-of-war between local and federal regulations, leaving some places caught in a legal limbo. Imagine this regulatory battleground. Some places forging ahead with their own rules, others entangled in legal spats, all trying to navigate their way through this maze of regulations and challenges. It's like a puzzle where every state and city was trying to fit their own piece into the larger picture of tackling these elusive ghost guns. The legal circus surrounding the Biden administration's federal rule on ghost guns. It's been quite the roller coaster ride. Brace yourself for this. There's been a flurry of lawsuits launched against this rule. Some suits, like a door hitting a wall, got rejected right off the bat. But wait, there's more. Others found themselves in the court limelight, waiting for their turn under the legal microscope. It's been a tug-of-war in the courts, with some of these lawsuits meeting an early end, while others are still in the ring duking it out. It's like a legal drama playing out in slow motion, each lawsuit adding another chapter to this ongoing saga. So picture this legal battlefield, lawyers on both sides gearing up for battle, arguments flying like arrows in courtrooms across the country. Some cases hit a dead end, while others are still in the legal pipeline, waiting for their moment to shine. It's a high-stakes game, and the legal wheel keeps turning as these lawsuits navigate their way through the judicial maze, all with the fate of the federal rule hanging in the balance. In the arena of ghost gun regulations, it's been a battlefield of political ideologies and industry opposition. Cue the conservative groups, gun lobbies, and the staunch opposition they've raised against the Biden administration's executive action. It's been a clash of perspectives, a battleground where opinions on gun regulations have collided head-on. They haven't just raised their voices, they've come armed with legal challenges, aiming to put a stop sign in front of these new regulations. But that's not all. There's this looming cloud of anticipation for potential litigation hovering over these regulations. The critics aren't just grumbling, they're prepping their legal artillery, ready to fire shots at these regulations. Their beef? They're pointing fingers, alleging that these new rules might be playing a game of tug-of-war with existing federal laws. This political standoff and industry opposition is like a game of chess where every move is being strategized, every argument carefully crafted. The opposition isn't just waving banners. They're gearing up for a legal showdown, expecting these regulations to face off against the weight of existing laws. It's a political tug-of-war, a legal chess match, with the fate of these ghost gun regulations hanging in the balance as political and industry forces clash over the direction of gun control policies. In the heart of a contentious debate swirling around gun rights and regulations, Georgia Congressman Andrew Clyde has taken center stage with legislation aiming to reverse federal rules concerning firearm stabilizing braces. This measure recently cleared the House Judiciary Committee, prompting celebration from Clyde, who labeled it a triumph for Second Amendment freedoms, with the next destination being the House floor. So what's all the fuss about these stabilizing braces? These accessories are designed to reduce the recoil of firearms, offering a gentler shooting experience, particularly beneficial for individuals with physical disabilities. However, a recent move by the ATF reclassified certain pistols as rifles under the National Firearms Act if equipped with these stabilizing braces. This reclassification has mandated gun owners to register their firearms or modify them to comply with the new regulations.
Pistol, it can become a short-barreled rifle, and then it's subject under the National Firearms Act. That's what you're saying.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Administration officials and anti-gun advocates and even the president himself mischaracterizing that immunity.
That are not designed and intended to be shouldered would be classified and not covered.
The stage is set for a significant clash, one that goes beyond the technicalities of firearm laws. It's a pivotal moment in the ongoing debate surrounding gun rights and regulations, with the fate of Clyde's legislation hanging in the balance. As the political tug-of-war continues, the implications of this bill ripple through the larger discourse on gun control, individual rights, and the accessibility of firearms in the U.S. A threat to legal gun ownership. The ATF's redefinition of stabilizing braces has sent shockwaves through the firearms community. Imagine waking up one day feeling perfectly fine about owning a pistol with a stabilizing brace. A device initially designed to assist individuals with disabilities in handling firearms, and suddenly being told that you might be breaking the law. That's the whirlwind lawful gun owners find themselves in when the ATF decided to reclassify these braces, effectively tagging certain pistols as short-barreled rifles. However, these accessories evolved. Enthusiasts within the broader gun-owning community saw their potential and began using them too. They adapted pistols for shoulder shooting, a practice that gained popularity and acceptance within the existing rules. But the trouble started when the ATF decided to scrutinize these accessories. They began to view pistols with stabilizing braces, especially those adapted for shoulder shooting, as a bridge too far. What once seemed okay under the regulations suddenly fell into a gray area. The agency's redefinition transformed a tool initially meant to aid disabled individuals into a headache for lawful gun owners. It blurred the line between what was legal yesterday and what might land someone in legal trouble today. In essence, the ATF's move took a helpful tool and turned it into a regulatory nightmare, leaving responsible gun owners feeling blindsided and uncertain about their status within the law. In 1934, President Franklin D. Roosevelt faced a brewing storm concerning firearm regulation. The issue at hand wasn't exactly about banning firearms, but rather controlling them. FDR was eyeing fully auto firearms for potential restriction, but the Department of Justice swatted that down, claiming it might breach the Second Amendment. Roosevelt, not one to take defeat lightly, pivoted. He introduced a legislative move that would set the stage for the National Firearms Act of 1934. This act didn't outlaw auto weapons, but put stringent rules around them. It demanded the registration of fully auto firearms, short-barreled rifles, shotguns, and sound suppressors. The aim wasn't eradication, but control through a registry, highlighting how the government wanted to monitor potentially more dangerous firearms without a blanket ban. The historical resistance against national gun registries aligns with this ethos. The NFA itself was initially a compromise to avoid a complete ban on certain firearms by implementing a registry. However, it set a precedent for government oversight and control, something that's raising eyebrows today. These actions by the ATF might be seen as contradictory to the principles enshrined in the Second Amendment, inviting debate about where the line should be drawn between gun regulation and an individual's right to bear arms without excessive government scrutiny or control. It's a historical recurrence that raises pertinent constitutional questions about the balance between public safety and personal freedoms. When experts start waving red flags, it's time to pay attention. Many seasoned voices in the firearms realm have raised serious concerns about the fallout of criminalizing stabilizing braces, particularly for disabled individuals. Dr. John Lott, president of the Crime Prevention Research Center, is one of those voices. He's been vocal about how these braces were initially designed to assist wounded and disabled veterans in handling firearms. These accessories were a game changer for individuals like Rick Cicero, a veteran who lost his arm and leg in Afghanistan. These stabilizing braces gave Rick, and many others, an avenue to defend themselves effectively. Cicero, an advocate for injured veterans, highlighted how these tools weren't just about shooting, but also a means of reintegration and getting injured veterans out and active. Well, it's about the unintended consequences. By slapping legal restrictions on these braces, the government is potentially harming those they were initially meant to help. Criminalizing these tools doesn't just affect mainstream firearm enthusiasts, but also disabled individuals who rely on them for their daily security, and more importantly, their sense of freedom and autonomy. The real question is whether these justifications hold water. Sure, incidents occurred involving these accessories, but the evidence doesn't convincingly link the braces to the severity or outcome of those crimes. It's a case of using isolated incidents to justify a sweeping ban that could have far-reaching repercussions, especially for those in the disabled community. It's a debate where the balance between public safety concerns and the unintended impact on the vulnerable requires careful consideration. Constitutionality clash. The clash between Second Amendment rights and ATF regulations is heating up, sparking a debate about the boundaries of gun ownership and governmental oversight. Let's start with the Second Amendment. It's the cornerstone of the debate, enshrined in the Constitution. It safeguards an individual's right to bear arms. This right isn't just about owning firearms, it's a fundamental liberty for many Americans. It's a guarantee that individuals have the means to defend themselves, their families, and their properties. It's a check on potential governmental overreach, ensuring that citizens maintain a level of autonomy and protection. Now, enter the ATF. As an agency tasked with enforcing federal gun laws, its actions are under scrutiny. The recent reclassification of stabilizing braces as a means to regulate firearms raises questions about its alignment with constitutional principles.
Well, I've got here the actual original brace that this letter was responsive to.
Again, I think the president has given numerous different times he's talked about this provision.
And the implementation of your rule. Did Congress pass a law? What changed?
Administration effort to regulate ghost guns for now. The court voted 5-4 to put a ruling on hold from a federal judge in Texas.
You're not exempting the same brace that you gave this letter to.
Some argue that the ATF's move infringes on Second Amendment rights by introducing unnecessary regulations that undermine lawful gun ownership. It's a delicate dance between regulation for public safety and encroachment on constitutional freedoms. The public response has been quite vocal. Many gun owners and advocates are up in arms, pardon the pun, about the ATF's redefinition. There's significant opposition to what's seen as an overreach of authority. It's not merely about the inconvenience or cost of compliance, it's about the potential erosion of constitutional freedoms. People are worried that this might set a precedent, allowing administrative agencies to exert undue influence on constitutional rights without proper legislative backing. Defending the right to bear arms. Affected citizens are rallying against the ATF's ruling, expressing concerns about eroding rights and excessive government control. Calls for action flood social media and advocacy groups, urging resistance against what's seen as overreach. Legal challenges loom large, with several gun rights organizations gearing up to challenge the ruling's constitutionality. Recent court decisions, particularly those emphasizing legislative authority over administrative agency rulings, offer a glimmer of hope. These decisions signal a potential path for legal challenges, fostering optimism among gun rights advocates for a reversal or at least a limitation of the ATF's directive and its impact on the right to bear arms. That's all for this video, folks. See you next time.